Hello and welcome to my Employment Law Snapshot. In this episode I'll be looking at a case where the court considered whether an HR team had inappropriately influenced a disciplinary process, the Rugby World Cup and Batman. As many of you'll probably already know, I'm a big fan of the sport of egg chasing. As such, I've been glued to the TV over the last few weeks watching as many of the World Cup games as possible. Over the years, I've made many friends with fellow egg chasing clients, many of whom support Scotland, Wales or Ireland. Needless to say, the banter between us over the last few weeks has been pretty robust as our respective teams have experienced the highs and lows of the tournament. However, after last week's debacle by the English team, it's fair to say that I've suffered the most in the exchange of jokes between my rugby chums. In the true spirit of sportsmanship, I've rather stupidly agreed that if England lost against Australia, which unless you live on another planet or like soccer ball, they did, I would broadcast one anti-English rugby joke suggested by my clients in this video as a forfeit. Unsurprisingly, there was only one joke out of about 15 that was suitable for broadcast, so here it is. What do you call an Englishman holding the Rugby World Cup? The engraver. My punishment has now been served. On with the law. This week's case is called Rampal against the Department for Transport. Mr. Rampal was employed by the Department for Transport, or the DfT. Now they undertook an investigation into a possible case of misconduct by Mr. Rampal in relation to his expenses. Mr. Goodchild was asked to investigate the allegations. However, as he didn't have much experience in carrying out disciplinary procedures, he received advice from the in-house HR team. Although the initial investigation report produced by Mr. Goodchild was partly critical of Mr. Rampal, it contained a number of favourable findings, including the fact the misuse of expenses was not deliberate and that Mr. Rampal's explanations were consistent and plausible. As such, Mr. Goodchild's recommendation was a finding of misconduct against Mr. Rampal and a sanction of a final written warning. However, following further communications between Mr. Goodchild and the HR team over a period of time, the favourable comments were removed from the report and replaced with critical comments, and the sanction recommended changed to summary dismissal for gross misconduct. In light of the changed report, Mr. Rampal was dismissed, and so he brought a claim for unfair dismissal. During the Employment Tribunal proceedings, evidence came to light that suggested that the HR team might have advised on factual and legal issues that went beyond matters of law and procedure. However, Mr. Rampal lost his claim because the employment judge concluded that the decision to dismiss him was still within the band of reasonable responses open to a reasonable employer. Mr. Rampal appealed to the Employment Appeal Tribunal and Mr. Rampal won. The central issue that was considered by the EAT was whether the employment judge had properly considered whether the HR team had inappropriately lobbied Mr. Goodchild about Mr. Rampal's guilt and what sanction to impose. The EAT took into account an earlier decision by the Supreme Court, which essentially said that the report of an investigating officer for a disciplinary inquiry must be the product of their own investigations. The EAT said that Mr. Goodchild's change of approach after the involvement of the HR team was disturbing, and it took the view that the HR team might have involved themselves on the issue of Mr. Rampal's guilt. The EAT went on to say that the changes of opinion were so significant that they gave rise to an inference of improper influence by the HR team, and therefore the employment judge in the original employment tribunal should have given clear reasons for accepting that there had not been any inappropriate influence. As such, the case was remitted back to the employment tribunal for further consideration. This case is really important for HR teams because they're understandably an important part of the disciplinary process. The moral of the story is that HR advisors have to be careful that they limit their advice to questions of law, procedure and process. If they overstep the mark and start to stray into areas of culpability or inappropriately influence the conclusions of a disciplinary investigation, it could potentially compromise the fairness of the process and result in an unfair dismissal. And finally, do you ever get the feeling that your colleagues at work are faking their cheerful smile when they're given a job to do? Well, if you do, you might want to consider following in the footsteps of some Chinese companies with their rather novel idea of allowing their employees to wear masks at work. Believe it or not, some Chinese companies encourage their workers to wear a mask to work as part of a relaxation day, so that they can pull whatever facial expressions they want without their managers knowing what it is. The rationale behind this idea is to give staff a day to de-stress and not feel as if they've got to put on a smile when they don't want to. Apparently, the masks can even be worn when dealing with clients and customers. So, the next time you come for a client meeting with me, please don't be overly concerned if I turn up wearing my favourite Batman mask. That said, after a bit of an issue last week, I think that I'm going to have to seriously reconsider whether it gives the right impression in the employment tribunal. Thanks for watching, I hope you enjoyed it. If you want to subscribe to our YouTube channel for more updates, please click here. If you want to follow us on our Twitter page, which gives you a daily heads up about everything employment law related, click here. Or if you want any more information, please go to our website by clicking here. Also, all of the links are below. Once again, thanks for watching and see you next time.